It has been nearly 2 months since the United States Supreme Court overturned the constitutional right to an abortion. According to the Guttmacher Institute, at least 43 abortion clinics across 11 states have stopped offering abortion care in the first month following the ruling. But just because abortion is no longer accessible in some states doesn't mean that women aren't doing everything in their power to get the care that they need. And sometimes that means traveling out of state. Care providers in states surrounding those that have banned abortion are seeing an unprecedented spike in calls from patients out of state. And it's important to remember that there are women and in some cases minor children behind those statistics. You might recall the story of a 10-year-old rape victim in Ohio who traveled to Indiana to terminate her pregnancy. And while abortion rights advocates and even President Biden use that little girl as an example of the tragic consequences of abortion bans, conservatives were questioning whether she even existed. And now a case surrounding a 16-year-old girl who was pregnant in Florida is making national headlines. Under Florida law, an abortion cannot be performed on a minor without the consent of a parent or her guardian. In a petition, the girl said she was mature enough to make the decision and that she's not ready to have a baby. She said she's still in school. She doesn't have a job and the father is unable to assist her. But a 3-judge panel on an appeals court ruled that she can't get an abortion because she, quote, lacked the maturity to make such a decision. So let me get this straight. In the court's eyes, a 16-year-old girl who has no parents, who is in the care of Florida's child welfare agency, who is still in school, who said she's not ready to have a child, is not mature enough to get an abortion, but she's mature enough to be a mother? Got it. Must be Florida. I have the perfect guest to talk to me about this. Retired Miami-Dade Circuit Court Judge Jerry Beth Cohen joins me now on set here in Miami. Judge Cohen, thank you for being here.
Thank you, Katie.
You and I have known each other for a while.
We have.
But there was this amazing kind of background to you that I was not aware of, and I just find it to be so incredibly relevant to what we're talking about. I want to first, though, get your reaction. You sat on the bench for decades. You heard these types of issues. What's your reaction to what this appellate court just did?
Well, these cases typically come to juvenile judges, and I presided in the Juvenile Dependency Division for many, many years. I was on the bench 28 years, and probably 60% of that was spent in dependency court. So I saw a lot, and I saw a lot of these cases. Now, I want to give you a caveat.
Sure.
The transcripts are sealed.
Yeah.
We can't see them. We know nothing about this girl, really, except what was in the opinion, the appellate opinion. And we know nothing about what she told the judge, except for what was in the appellate opinion. So you hate to second-guess a judge.
Sure.
When I was a judge, I didn't like being second-guessed. So I want to give you my opinion and tell you how I handled these cases, because there may be something we don't know.
Sure.
These dependency cases are all sealed. They're confidential. But with this statute, and by the way, I'm against these statutes. I'm opposed to them. I think they put a burden on these minors that don't need to be there, because most minors will go to a parent if they feel they can.
Okay.
Okay. I was pregnant as a minor, and this was before Roe v. Wade, and I was able to go to my mother, and my mother took me to New York, where it was legal at the time. I was petrified. I was scared to death to tell her, but I knew that if I went to her, I wouldn't be kicked out of the house, I wouldn't be shamed, I wouldn't be beaten. So I was able to go. So most of these minors will go to a parent. Now, this minor is parentless. She's in the custody of the state of Florida. Her guardian and her caseworker were at the hearing. Apparently, she lives with a relative. Now, from what I can understand, she did not have the requisite paperwork wherein the relative gave consent with a notarized document. However, once in court, from what I could tell from the appellate opinion, she was able to articulate why she wanted the procedure.
As we heard, yep.
She was able to tell the judge, look, the father's not involved. I have no money. I've had a lot of trauma in my life. I've been re-traumatized because a friend died. I am not financially, physically, or emotionally able, given my life circumstances, to have a child. And she, in fact, said, I considered having the child, or I considered wanting the child, but I'm just not capable.
How is that not enough then, Judge Cohen, if that, it sounds like a level of maturity?
The truth of the matter is that is maturity.
Yeah, of course.
When somebody, and keep in mind, this minor is nearly 17 years old. This is not a 13-year-old. This is a 17-year-old who is coming into court and saying, look, I've gone to the clinic, I've Googled the risks of this procedure, which are very low. I've talked to the people at the clinic. I've talked to my guardian ad litem. I've talked to relatives because apparently she went to the clinic to get information with a relative. And I have come to the decision that this is not right for me at this point in my life. Now, apparently, and I read this in the appellate decision, one of the judges on the appellate court said, it seems that the key issue for the judge was that she wasn't really sure. Well, if she changes her mind, even if she has the waiver, she doesn't have to go. The waiver doesn't say you must go get an abortion.
It gives you the chance to do it.
It gives you the chance to do it. It says you are considering pros and cons. You have the opportunity now, because you have shown maturity, to get this procedure and or to seek counseling from family on the outside or from the staff at the clinic.
Let's talk about how time is not an ally for this young girl. She apparently, according to the appellate opinion, was 10 weeks pregnant when she came to the judge with her handwritten petition, no legal representation, which is also kind of an interesting factor here, and said, I want to go and get this abortion. I mean, we've got a 15-week abortion ban in Florida. The way that things work in our judicial process, what are the chances of her actually reaching a point in the pregnancy kind of timeline where this may not be an easy thing for her to
fix? There's a 15-week ban in Florida, as you know, Katie. So after 15 weeks, you have to travel out of state. In addition, up until I think about 12 weeks, it may be less than that. I know at 10 weeks you can get a medical abortion, which means there are pills you can take. You can go to a clinic, obtain those pills from a doctor, and then you can go home and have the abortion at home. Very safe, but if there's a complication, you can always come back into the clinic. She will be forced to now have, most probably, a surgical procedure, which is much more expensive. And if she has to travel out of state, that further complicates the matter. It just isn't clear. The judge in this case, the trial judge, gave this young woman a chance to come back into court, you know, as if that's an easy thing to do. And if she does go back into court, hopefully she'll opt for a lawyer, because you are permitted to get a lawyer for free in Florida for these cases.
Before I have to let you go, in 1989, you founded an organization called Women's Emergency Network, and you mentioned that this girl may have to travel out of state, but a lot of these girls don't have the funds, they don't have the means. Tell me about the Women's Emergency Network and why you founded it back in 1989.
Well, the Women's Emergency Network is part of the National Network of Abortion Funds. And I founded it because I knew that I had the possibility to get an abortion when I was a minor, because I had the money to travel. I was privileged. But there are so many women. I mean, most of the women that get an abortion are minorities. There are so many women that can't afford it. So what the Women's Emergency Network does is it provides funding for women who can't afford an abortion. And there's another organization in Florida called Florida Access Network, and they help with logistical monies. So there is a whole network of funds all over the country ready and poised to help women all over the United States to travel if need be.
Women or sadly, girls, minors,
right,
which may be at this point. Judge Jerry Beth Cohen, I want to appreciate you for being so transparent about your own personal experience. I know it's not always easy to talk about, but for letting us know about what your experiences were like sitting on the bench, because these judges, they do sit in judgment. I mean, that's what the job is. But for you to come and give us some insight and analysis, we really appreciate it. So thank you so much for being here today.
Thank you for having me, Katie.
I appreciate it.